Who have we got here, Robolawyer? Oh, it's your friend Pencil Dog. I wonder why we're calling Pencil Dog. He's got a nose. Becomes a pencil, in and out. But we're talking about criminal law responsibility and defences today. It's the second part of our modules on criminal law. And we start off by looking at some very basic concepts which make criminal law different from other areas of law. And the first one is the idea of the limitation period. Well, normally the law says you can't bring an action after a certain amount of time because there's a period of time called the limitation period. But in the case of criminal law, there is generally no limitation period, although in some cases you need permission of the Attorney General, because in a lot of cases, especially involving offences which allegedly occurred many, many years ago, the evidence may no longer be available, the witnesses may not be as liable, or reliable, so I should say reliable, not liable witnesses. Now, we look at also the idea of double jeopardy, how a person cannot be tried again for the same offence. The idea with criminal law is that there has to be a sense of finality. We also look at some ideas about where the defence of a previous acquittal or a previous conviction for the same offence has been used before. They're French terms, autrefois convict, previously convicted, and autrefois acquit, previously acquitted of that particular offence. The other thing is sometimes the law says, well, if a person tries to commit an offence but doesn't succeed, should they be held criminally responsible? Well, in a lot of cases the answer is yes, because an attempt to commit an offence is considered as morally culpable as actually committing the offence. And there's a lot of writing about what constitutes an attempt. When does the attempt begin? When have they put the purpose into practice? The illegal purpose, when does it actually begin? And that's all tied up with these ideas of attempts. Similarly, we look at the idea of who's a party to the offence. The person who commits the actual offence is called the principal offender, and there may be other people who've assisted the person along the way, either before or after, and they're called accessories. It's important to realise that the criminal law didn't want to attribute blame to people who were not, shall we say, morally responsible. So there were ways where people could avoid criminal liability, say through things like the defence of accident. I'm just turning over my overheads here so we can have a look at them. And in fact, one of the requirements that used to be the case, and still is in a lot of criminal offences, is the idea of a guilty mind, or mens rea. And if the guilty mind isn't there, well, then the person should not be convicted. However, there are other offences called strict liability offences and absolute liability offences, which can you don't need to have the guilty mind. And in fact, whether an offence is a strict liability offence, absolute liability offence, or requires mens rea, you actually have to look at the legislation, Robolawyer, to see what they mean. Now, I guess I can give an example. Let's say it's a case of plagiarism, and that's something very relevant to the students, because let's say, supposing someone gets someone else to do their assignment and hands it in. Well, that's fairly much a clear-cut case of plagiarism. they're handing in the work of someone else as their own, and they're doing it deliberately. And I think we could safely say they've got a guilty mind and intention to do it. What about, say, someone who's doing their assignment and forgets or doesn't quite know how to reference properly, and as a result puts in material from other sources and doesn't sufficiently acknowledge it? They're guilty of plagiarism. They're trying as hard as they can. Yes. Now, if plagiarism is a strict liability offence, yes, so they probably are guilty of plagiarism. If, on the other hand, we say you've got to have a guilty mind, in fact, a lot of universities actually draw the distinction between deliberate plagiarism, where the person intends to hand in someone else's work and ideas as their own, and the negligent or inadvertent plagiarism, where the person makes errors in referencing. And so that's an example of the need for a guilty mind. Sometimes we also, when a person's been convicted of an offence, we look at what's called mitigation of the penalty, and the court takes into account factors which will reduce the penalty which could be applied. Sometimes a person can actually have committed the offence but may be able to raise a defence, which means that they are acquitted, they are found not guilty. And there are a number of defences listed: in provocation, self-defence, honest claim of right. Honest claim of right. Now, honest claim of right means you actually thought that you were entitled to do what you did in dealing with that property. You might be under a mistaken impression that it's your property, or that you have the permission of the owner to deal with it. So, like if you go into someone else's yard, pencil dog, they may think, well, you're trespassing. But if you really honestly believe that you're entitled to do that, you could perhaps raise the defence on this claim of right. Mightn't work. I don't know. The automatism, that's a bit like the sleepwalking. Insanity, there are also other defences. What's that, Robolawyer? What happens if a person's intoxicated and does something silly? Can they raise that as a defence? The answer is generally no. You can't use self-induced intoxication as a defence, generally. I say that. And then there's the mistake. And there are two sorts of mistake. There's a mistake in law and a mistake of fact. Now let's say you bring in, say, 100 grams of heroin into Australia, and you think that the law in Australia allows you to bring in heroin, which it doesn't. You'd say that you made a mistake of law. Now that's no defence. The fact that you didn't know, you interpreted the law wrongly, misunderstood the law, is no defence. You're still liable. However, if you were to bring in 100 grams of heroin, believing it to be white sugar or something, that's a mistake of fact, and you may be able to use that to avoid liability. In fact, if you have a look at the legislation, both the Commonwealth Criminal Code and State Criminal Codes, they spend a fair bit of time looking at this issue of criminal responsibility and liability, because in many cases people who do commit what seems to be an offence may have an effective defence or may not be criminally responsible. That's about it for this week, Robolawyer. Say goodbye, Robolawyer. You're up on YouTube now as well, so people who aren't in the course can actually go and watch. Now, we're not getting a lot of hits, but we're not getting a lot of nasty comments either. So that's really good, I guess.